Fundamental Rights. Introduction. The Indian Constitution 1950 contains certain provisions which guarantee the basic human rights of all the citizens of India. There are six fundamental rights and they are immune from any kind of discrimination based on religion, race, gender, etc. These rights can be invoked by individuals if there is any violation of them. Fundamental rights are included in Part 3 of the Indian Constitution. It is also known as the Magna Carta of the Indian Constitution. Through this article, we will find out more about the fundamental rights enshrined in the Indian Constitution. Schedule of Fundamental Rights. There are six fundamental rights enshrined in the Indian Constitution. They are as follows. First, right to equality. Article 14 to 18. Right to freedom. Article 19 to 22. Right against exploitation. Article 23 to 24. Right to freedom of religion, that is Article 25 to 28. Cultural and educational rights, Article 29 and 30. Right to constitutional remedies, Article 32. It is pertinent to note that the right to property was one of the fundamental rights in the Constitution. However, the right to property was extracted from the Schedule of Fundamental Rights by the 44th Constitutional Amendment Act in 1978. Being under the scope of fundamental rights, the right to property was acting as an obstacle in achieving the goal of property distribution, equality, and socialism. Thus, at present, the right to property is a legal right under Article 300A and not a fundamental right. We will talk about silent features of fundamental rights. The following are the few features of fundamental rights enshrined in the Constitution of India. The Indian Constitution guarantees and protects fundamental rights. The Parliament has the power and authority to restrict the fundamental rights on reasonable grounds. However, such restrictions can only be made for a fixed period of time. The grounds based on which the fundamental rights are restricted by the Parliament will be reviewed by the judiciary for reasonability. Therefore, the fundamental rights are neither absolute nor sacrosanct. Fundamental rights can be suspended in the case of national emergencies. However, the rights guaranteed under Article 20 and 21 will still be applicable. In the case of military rule, fundamental rights can be restricted in any area within the Indian territory. The Constitution of India enables an individual to move directly to the Supreme Court of India for the enforcement of their fundamental rights in case they are violated or restricted. The fundamental rights are thus justiciable. Now, importance of fundamental rights. Fundamental rights acts as a foundation that upholds the democratic system and secularism in India. They are established the essential conditions for an individual's material and moral protection, ensuring social justice and equality. They also defend the rights of minorities and other weaker sections of society. Fundamental rights also ensure individual liberty. These rights establish the rule of law, thereby keeping a check on the absoluteness of the government's authority. Amendability of fundamental rights. The Supreme Court, in the case of Keswanand Bharati in 1974, that the Parliament can amend any part of Constitution, including all the fundamental rights, subject to the doctrine of basic structure of the Constitution. The Supreme Court has neither specifically defined as to what entails the basic structure, nor did it mention any exhaustive list regarding the contents of the basic structure of the Constitution. The Apex Court, however, stated that only additions can be made to the basic structure and no deletions will be allowed to be made. The Supreme Court, in a catena of judgments, has held that the following provisions are a part of basic structure of the Constitution: sovereignty of India, democracy, secularism, republic, free and fair elections, judicial reviews, etc. Now we will talk about doctrine of severability. The doctrine of severability is also known as the doctrine of separability. It protects our fundamental rights since it is enshrined in Article 13(1) of the Constitution, stating that all the law implemented in India before the initiation of Constitution shall continue to be in the force, however the extent to which they are in conflict with the fundamental rights will, to the degree of such irregularity, be void. In simple terms, the entire law would not be held invalid or void, only the part of law which is inconsistent with the fundamental rights shall be held void or invalid.